Tonight we're going to talk some common myths about medical malpractice suits. They're widely believed because just as there is a certain mythology around aspects of medicine, there is some mythology around the law as well. One of those, of course, is that patients and families sue because they're greedy. They're looking for the big buck. They're rolling the dice, hoping for the settlement that will put them on easy street for the rest of their lives. Another is the notion that every unhappy patient has a cousin Vinny. Some lawyer will take their case, no matter how ridiculous, and file a nuisance lawsuit to destroy anyone and everyone who ever came near that patient. There's another myth that if you go in front of a jury, you're dead. The juries will always rule against the deep pocket. In this case, the hospital, the doctor, particularly if they think that there's malpractice insurance that will cover it anyway. If you say you're sorry, it'll hurt you in court. So with that goes the myth that the best defense is always clam up, hunker down, and get ready to fight. And I will tell you, those myths have dominated the thinking of the legal profession around malpractice suits in various professions for a very long time. Patients and families do not sue because they are greedy. There's been a lot of research done in this area, and in fact, most of the time, if a patient or a family brings a lawsuit, it's for one of two reasons. Either they're angry because they feel they've been given the runaround, they were stonewalled, they were disrespected, people were too arrogant or heartless to reach out to them in the wake of a medical error, or because, one way or another, it was the only way they thought they could possibly find out what happened to someone they loved. If you follow the standard practice of clamming up, hunkering down, pulling away, and refusing to talk to people in the wake of a mistake, they're going to think they're facing a cover-up, and they're probably going to go find a lawyer who will sue you so that in depositions or interrogatories or some other horrible torture system devised by lawyers, they can find out what really went wrong. Money is typically the third consideration. But I'll tell you this much. If they're angry, if they're offended, and if they're puzzled and confused and don't think there's any other way to find out what happened, money becomes the first consideration because they start looking for a way to pay you back. So it's not about the money to begin with, but it can get there sooner or later. Any unhappy patient can find a lawyer. Not at all true. The way the legal system in this country is structured does give an advantage to plaintiffs. And that's because the people who write the rules, who, not surprisingly, are mostly lawyers, think it's terribly important for folks who have suffered a genuine injury to be able to get their day in court. And there's always been a concern articulated by a significant and rather vocal percentage of my colleagues that if the winning party could get their legal costs paid by the losing party, then people without a lot of money would be afraid to file suit even if they had a legitimate claim. So the way things are structured now, plaintiffs' lawyers frequently work on contingency. For them, a case is a roll of the dice. They will file a claim and take a percentage of whatever they're able to get for their clients. That gives them a powerful incentive to win. Defense attorneys, on the other hand, and I will tell you that's my background, either are on salary somewhere in-house with a company or an association as I was, or they work on an hourly rate. Which means that every time you pick up the phone and call one of them, unless they're in-house, you're spending money. So there's a tendency to think that the plaintiff's lawyers are always going to grab at the case because they're going to file nuisance suits and make a lot of money. And that the defense lawyers are always going to want to keep them going, keep them going, keep them going until the hourly rate gets up to where it needs to be. But I'll tell you, there's more truth to the latter than the former. And let me tell you why. As busy as lawyers are, a plaintiff's attorney cannot afford to take a lot of cases that he or she isn't pretty sure can be won. Juries like you. They believe you, and based on what I'm going to tell you, they're going to like you even more if, heaven forbid, you ever find yourself in that horrible situation. So with all of that, the odds of your being successfully sued for malpractice at any point in your career are really very low. So at that point, you're sitting there thinking, okay, why worry? Well, there's a reason, and let me tell you why. being sued for malpractice can turn your life upside down. Thankfully, there is a better way. Now, this is scary, but I'm going to ask you to bear with me because I can demonstrate to you why this works. In the wake of medical error, you have another alternative, which is to acknowledge the error and make an effective apology. An effective apology can significantly reduce your risk of lawsuits. Think back to what I said about why patients sue or their families. They're angry. They want to find out what happened. They're looking for fair compensation. If you make an effective apology, you will soothe that anger because you'll have approached these people with respect and courtesy and listened to what they had to say. You'll explain what happened so they won't wonder anymore. And part of making an effective apology is making appropriate amends for the harm. But it does a couple of other important things too. It restores your patient's trust in you. I can tell you from having taken other professions through this process that everyone knows you're human, no matter how good you are. I know a doctor who likes to point to the initials on his jacket and say, this is MD, not GOD. They're delighted that he knows it, but they had already figured it out. They know you're not perfect. And if you're willing to admit that you're not, that you did the best that you could, most people will forgive you. And they would never think of taking you to court. If you apologize for a mistake, it'll help you recover from the trauma of having made that mistake. Professionals are very hard on themselves. They hold themselves to very high standards. They find it hard to forgive themselves when they've made an error, especially if in the process they hurt somebody who was depending on them to help them instead. If you don't remember another thing I say to you tonight, remember this. It's all about relationships. If your patients like you and believe that you like and respect them, they are much, much more likely to forgive you if you make a mistake that injures them. Don't cut corners on disclosure. I know you hear this from your legal team all the time, and with good reason. That duty to warn argument is one that you can explain to a 5-year-old. This could have happened and the doctor didn't tell that mommy and mommy got sick. Piece of cake. But what I'm finding is because so often the disclosure requirements are so onerous, doctors are cutting corners. They're saying, well, you know, you could have this and this and this. I don't really need to tell you this, right? Because they've said it 100 times and they don't want to say it 101. But I will tell you from experience working with professionals in various walks of life, the one you don't tell is the one you should have. And be very careful about medical speak. One of the things that your profession and mine have in common is an unfortunate fondness for Latin and various and sundry other difficult technical terms. What you do is hard, it's complicated. It's why you had to take so long learning to be a doctor or a nurse. But nonetheless, if you can't explain it to me in terms that I understand, how can I give you informed consent? So work with your attorneys, work with your risk managers to come up with ways to explain to your patients in clear, understandable English what's going to happen to them and what the possible consequences could be.